You pull back your bedroom curtains on a Tuesday morning and freeze. A small black plastic dome sits mounted on your neighbor's roofline. Its lens tilts downward, staring directly through your second-story window. Your immediate reaction is an adrenaline spike of pure, raw violation. You call local police, expecting immediate sirens, citations, and fast removal. Then, the officer delivers the bad news. It is completely legal. Right now, in 2026, millions face an unblinking neighborhood standoff. To understand why your bedroom became public theater, look at the law. Domestic privacy law rests on the 1967 Supreme Court case, Katz. Justice Stewart ruled that whatever you knowingly expose loses constitutional privacy protection. This established the foundational legal rule known as the plain view doctrine. If someone standing on their lawn can see inside, a camera can too. The law views a standard security camera as a mechanical eyeball. If you leave blinds open, the law assumes you consented to viewers. But that permission collapses the moment technology exceeds normal human vision. In 2001, the landmark Kylo ruling drew a line. Sense-enhancing technology not in general public use violates reasonable privacy expectations. Standard recording of plain view is legal. Thermal imaging through walls is not. Optical zoom penetrating closed blinds similarly crosses into illegal surveillance territory. Spatial context dictates legal boundaries just as much as optical hardware. Your front porch, driveway, and open yard carry zero reasonable privacy expectation. Anyone on a public sidewalk can legally watch you fetch the morning mail. But your bedroom, bathroom, and fenced yard occupy a separate legal category. Society recognizes an interior bedroom as an absolute sanctuary of personal privacy. Crossing that line turns an annoying property dispute into a state crime. Several states wrote criminal statutes targeting predatory domestic surveillance cameras. California Penal Code Section 647J punishes optical room peeping. New York Penal Law Section 250.45 penalizes bedroom recording. In New York, that offense is a second-degree Class E felony. Texas Penal Code Section 21.15 makes invasive recording a felony. Florida Statutes Section 810.145 prosecutes digital voyeurism felonies. If a neighbor intentionally records private bedroom activity, police can make arrests. The hardest hurdle is proving what the lens is actually capturing. Modern security cameras feature wide-angle lenses spanning 140 degrees. A camera aimed at a side walkway naturally catches your window background. Under state law, incidental capture of neighboring property is almost always legal. But a massive legal trapdoor hides in plain sight: audio. While video rules are permissive, domestic audio surveillance laws are strictly enforced. Under federal law and 39 states, one-party consent is the baseline standard. In those 39 states, one conversation participant can authorize recording. But exactly 11 states require two-party, all-party consent for audio capture. Those 11 are California, Delaware, Florida, Illinois, Maryland, and Massachusetts, along with Michigan, Montana, New Hampshire, Pennsylvania, and Washington State. An outdoor camera recording your private backyard conversations violates state wiretap laws. In those 11 states, default security microphones capturing neighbors risk criminal penalties. Millions of homeowners accidentally commit wiretapping simply by leaving audio enabled. What happens when cameras record video only and police refuse to help? Municipal ordinances regulating residential camera angles are exceptionally rare across America. One rare zoning model is Sunnyvale Municipal Code 19.42.080. Sunnyvale banned field-of-vision intrusion onto neighboring lots and restricted mounting heights. Without local zoning or HOA covenants, your remaining path is civil court. That means suing your neighbor for private nuisance or invasion of privacy. To win an injunction, you must prove substantial, unreasonable interference with property. You must show continuous surveillance causing irreparable harm money cannot easily fix. Let us examine the real financial cost of taking a neighbor to court. Small claims court filing fees run between $10 and $75. But small claims courts rarely have authority to issue mandatory injunctions. Forcing camera removal requires filing a full civil suit in Superior Court. Baseline civil filing fees range from $150 to $450. In California, the baseline Superior civil filing fee is $435. Once you retain an attorney to handle hearings, legal fees explode quickly. Attorney costs for a nuisance camera injunction average $5,000 to $10,000. That is $10,000 spent simply defending privacy inside your home. Civil damages can be significant if you prove willful, predatory surveillance. California Civil Code 1708.8 allows $5,000 to $50,000 fines. Yet an 18-month court war against someone 20 feet away is exhausting. This legal friction triggers a destructive psychological trap between adjacent homeowners. When people feel constantly watched, their immediate instinct is retaliatory counter-surveillance. You mount an equally powerful camera aimed directly back at their house. Soon, two plastic lenses spend 24 hours a day recording each other. Taking out garbage becomes a tense, tactical drill under silent electronic observation. Security hardware rarely creates community safety. It often institutionalizes mutual neighborhood paranoia. Most neighbors do not install cameras because they are criminal voyeurs. They mount them out of exaggerated anxiety, property disputes, or technical ignorance. Instead of spending $10,000 on litigation, use 5 practical steps. Step 1 is gathering photographic evidence from inside your affected room. Document the lens aiming directly through your glass to establish line of sight. Step 2 is having a calm, disarming conversation focused on window angles. Politely explain that their camera points directly into your private living space. Ask if they can angle the bracket down or enable privacy masking. Most modern security software can black out adjacent windows with digital boxes. Step 3 is reviewing your homeowners association rules or residential lease terms. HOAs regularly enforce nuisance bylaws and architectural restrictions on intrusive external hardware. Step 4 is citing wiretap statutes if you reside in two-party consent states. Written notice about illegal audio recording often forces an immediate hardware reposition. Step 5 is deploying simple physical countermeasures to block the visual feed. $20 of one-way reflective window film stops daytime viewing completely. Tall potted bamboo, dense hedges, or exterior shade sails sever sightlines permanently. Never use lasers against lenses, which creates criminal property damage liability. Consumer technology makes continuous neighborhood surveillance cheap and effortless. But possessing a legal right to aim a lens does not make it decent. You cannot always force a neighbor to show basic spatial respect. But knowing the law lets you calmly take your privacy back.